Hello and welcome to the AIFC Court and IAC Webinar Series 2020, New Opportunities During and Post-COVID-19. My name is Chris Campbell-Holt. I'm the Registrar and Chief Executive at the Court and Arbitration Centre. Today, we have the webinar 3 in our series of 15 webinars being conducted between now and the end of June this year. Today's topic is Force-Majeure Part 1, Kazakhstan and the AIFC, a comparative approach and related dispute resolution at the AIFC Court and IAC. I'm delighted that today and grateful to Mr. Bakhyt Tukulov to be our speaker, who is a partner and head of dispute resolution at GRATA International Law Firm, a leading law firm in Kazakhstan. We're also particularly grateful to Bakhyt and his firm GRATA for their membership and continued support of our user committees at both the Court and Arbitration Centre. Today's presentation will be recorded for further use, and we ask that if participants wish to ask questions that they simply raise a hand, and then Bakhyt will, at the appropriate time towards the end of the presentation, answer the questions. Without further ado, I hand over to Bakhyt. Bakhyt.
Thank you very much, Chris. Thank you very much for this excellent opportunity to speak at this webinar. We are very grateful for AIFC Court for this assistance, and we hope to continue to work together. The topic of today's webinar is very interesting, and I hope many of the visitors of this, viewers of this webinar will find it interesting. The idea was to compare regulation of Kazakh law and the AIFC law in terms of force majeure and see what are the benefits of one or another. As you know, AIFC operates on the basis of the AIFC constitutional statute, and AIFC constitutional statute provides that AIFC law applies between participants of the AIFC, between participants of the AIFC and AIFC bodies, and between AIFC bodies, unless excluded by agreement expressly. The parties are also free to choose AIFC law to their contract. However, when you expressly choose to apply AIFC law, you automatically submit, you're considered to automatically have submitted to the AIFC court's jurisdiction, unless you expressly agree otherwise. So in theory, a company which is not registered at the AIFC, or if those companies are not registered at the AIFC, they can in theory submit to AIFC law. And at the same time, if they so wish, they can opt out from the jurisdiction of the AIFC court. And for example, they can submit to the jurisdiction of the AIFC International Arbitration Court. As for AIFC law, AIFC contract regulations govern issues of force majeure. On the next slide, you will see relevant provisions from Kazakh law and AIFC law. There's only one provision in Kazakh law, which, when I say Kazakh law, I mean Kazakh civil code. Kazakh law contains only one provision, which relates to force majeure. It's Article 359, Section 2. It basically sets out that a party is liable for a failure to perform or improper performance of its obligations in the course of commercial operations, unless he proves that the failure was a result of force majeure, namely circumstances extraordinary and unavoidable in such conditions. And then there's a list. In particular, such circumstances do not include absence of goods, works, or services required for the purpose of performance. So basically, if you read Article 359, it refers to a situation when a party is not capable of performing an obligation when it, because of some external event, and when such performance is impossible. So the standard is relatively high. So basically, you have to indicate that it was impossible to perform an obligation. The standard is relatively lower as we read AIFC contract regulations, Article 82. It provides that except with respect to a mere obligation to pay, and we will come to payment obligations later, non-performance by a party is excused if that party proves that the non-performance was due to an impediment beyond the party's control, and that the party could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract, or have avoided or overcome it or its consequences. So I understand that what is unusual about AIFC contract regulations is that we all understand that AIFC operates on the basis of common law principles. It doesn't apply common law directly, but AIFC contract regulations are drafted on the basis of principles of common law. But if you apply common law directly, then there is this doctrine of frustration in common law, which is somewhat complicated, and it's as I understand it, I'm not an English lawyer, but there are many disputes about this lack of clarity on the application of the doctrine of frustration. So the objective of the drafters of contract regulations was to maybe provide some sort of flexible mechanism to set out conditions where a force majeure can be invoked, because force majeure is not something which is not a doctrine which exists in common law. On the next slide, you can see we've split into different criteria, and we try to compare the standards applicable to force majeure under AIFC law and under Kazakh law. The words in brackets are taken from Russian judicial practice. There is virtually no judicial practice sufficient or maybe clearly stated judicial practice in Kazakh law from Kazakh courts. Particularly, Supreme Court has not issued any guidance as to how to apply laws relevant to force majeure. So we've taken this from reviews issued by the Russian Supreme Court and Russian High Arbitrage Court, which are based on relatively similar force majeure provisions, and that's why we think that it's appropriate to invoke similar rationale in the interpretation of the Kazakh Civil Code. So extraordinary character of events or circumstances referred to a situation where some circumstances are exceptional, beyond normal, unusual, something which cannot be taken into account under any circumstances. So as you may see, this is a relatively high threshold compared to AIFC law, which requires that certain circumstances should be beyond the party's control. So in that sense, AIFC provides greater flexibility. Civil Code provides that force majeure circumstances must be unavoidable. So unavoidability refers to a situation when everyone in a similar business could not have avoided the circumstance or its implications. For example, if a tenant of a restaurant, owner of a restaurant, cannot make a payment, and we will come to payment obligations at a later stage, cannot make this payment on the basis of this force majeure, then it's going to be very difficult for such tenant to prove that not only him, but entire business of similar restaurants was affected. So it's relatively high threshold compared to a situation where under AIFC law, you should prove that such circumstance could not have been reasonably expected or avoided. So, but we are yet to see how this provision will be interpreted by the AIFC court. But in any case, at the first reading, it suggests some greater flexibility. Kazakh law also sets out that force majeure does not include a situation where goods or services are not available at a certain market. And there's also a clarification that force majeure does not include provisions which are external or which do not depend on the actions or will of the party to the contract. And we will come to that a bit later. So on this slide, we've done some comparison of the scope of events which might be considered the force majeure under Kazakh law and AIFC law. Kazakh law provides that a contract may set out other grounds for liability or a release from force majeure. And Article 374 also sets out that if a party's performance has become impossible due to circumstances for which neither of the parties is liable, performance cannot be demanded unless otherwise stated in laws or a contract. So in theory, parties may agree contractually under Kazakh law that certain events will or will not be considered a force majeure. But even though Articles 359 and 374 say so, I wouldn't be absolutely confident that such provisions would be upheld by Kazakh court. For example, in theory, based on these provisions, one can argue that parties can contractually exclude COVID-19 from the list of contractual force majeure, for example. They can specifically state that COVID-19 will not be considered a force majeure. But the problem is that as a Kazakh lawyer, I'm not sure that provision will stay and will be upheld by the Kazakh court. So in that sense, it looks like AIFC law will provide greater flexibility because Article 11 of the AIFC contract regulations provide that parties may derogate from AIFC contract regulations. And my understanding is that based on common law principles, the court will give very high weight on the language of the contract. So if parties agreed to exclude certain events or to, for example, consider certain events as force majeure, then it's very, very likely that the court would uphold such provision, which the parties agreed. So on the next slide, causation. We received many questions as to whether certain events amounted to force majeure or not. And one of the easiest ways to analyze whether or not a party is affected by force majeure is to see, is to identify what is the specific obligation in question. For example, if we're speaking of a lease agreement, there are two obligations: the obligation of the tenant to make payment and obligations of the landlord to provide space. So if we're asking, so the party which is invoking force majeure needs to prove that the relevant obligation was not capable of being performed in light of force majeure. For example, if it relates to leasing office space, a landlord cannot raise force majeure argument because by the state of emergency decree of the president, companies are not prohibited from leasing space. So there is no clear restriction in the decree of the president. So there's only a clear restriction on some public on organizations which like shops or maybe some public events. So the landlord cannot make an argument that, look, I was not able to lease you an office space because of the force majeure. So in theory, the landlord can perform the obligation to provide office space. But another question, and on that basis, the body which receives performance of the landlord, the tenant, cannot refuse to pay because, in fact, the leased space is provided, and he cannot make a force majeure argument. And even if such a tenant is not capable of actually coming to the office because of the quarantine and actually using the space. So when you consider whether or not the force majeure argument can be raised, one needs to establish causation between a specific obligation in question and the effect of the force majeure circumstances. So COVID-19 in itself is not a force majeure, but the events which are associated with COVID-19, such as the state of emergency decree or maybe some other decrees, the quarantine, which prevent performance of a certain obligation, may amount to force majeure. So this should be taken into account. Same applies to interpretation, as I understand, of AIFC contract regulations, Article 82. There's been a lot of debate and a lot of discussion on monetary obligations as to whether force majeure can be invoked for the purpose of performance of monetary obligations. Kazakh law is technically silent on that point, as opposed to Russian law, for example. Kazakh law is silent. Russian law clearly prohibits application of invoking force majeure in relation to monetary obligations. And I wrote a couple of articles saying that the standard for the application of force majeure should be reconsidered in Kazakh judicial practice because of the effect and the scope of this of the impact of COVID-19. Kazakh law is silent on, yes, but analysis of judicial practice suggests that the Kazakh courts have taken a consistent approach that they would not invoke force majeure in relation to monetary obligations. So although this is not clearly stated in the law, it follows from the legal theory and the practice of Kazakh courts that they would not apply force majeure to monetary obligations. And as opposed to that, AIFC law is very clear. It clearly says that monetary obligations cannot be invoked in relation to force majeure. So AIFC, I cannot say this is good or bad, but at least AIFC law is very clear in terms of monetary obligations. And one interesting thing which I discovered when I was preparing for this webinar is on 21st April, Russian Supreme Court issued an overview of judicial practice relevant to COVID-19. And although Russian civil code clearly, like AIFC law, clearly prohibits application of force majeure to monetary obligations, they made a very serious exception. And I wrote an article on this today, this morning, and published it. And Russian Supreme Court said that although force majeure does not apply to monetary obligations, it can be applied to monetary obligations in situations where a party could not make money because its activities were restricted by the effect of the force majeure. And they gave an example of when, for example, a restaurant owner is not capable of making a payment to the landlord for the use of the restaurant space. And if this was caused by direct restriction of the state to actually operate this restaurant, then in such case, the restaurant tenant is excused of the payment of sanctions or penalties for delayed payment of the lease payments. So, and it's somewhat weird, unusual, but again, bearing in mind the impact of the COVID-19, unlike any previous events which globally happened, such serious reconsideration of judicial practice might be appropriate. So we are yet to see whether Kazakh courts would follow the same approach, or maybe a AIFC court would also consider such an argument. So on the next slide, you can see potential remedies which a party can seek when a force majeure event occurs. Generally, you know, my position based on this comparison of Kazakh law and AIFC law suggests that AIFC law is different, but the key feature is that it provides far greater clarity, and it allows parties far greater flexibility to contractually agree certain provisions. So basically, if parties spend sufficient time working out their contractual relationship, then AIFC law will provide far greater predictability compared to Kazakh law. For example, in relation to remedies available in the event of force majeure, Kazakh law is not sufficiently clear as to whether a party may terminate the contract with reference to force majeure. There is Article 374, which says that an obligation is terminated due to impossibility to perform, but it's silent as to what should be the effect of the force majeure. For example, would it be reasonable to terminate the contract if force majeure lasts for a week? Would it be reasonable to terminate the contract on basis of this provision if the events act for a month? Our review of the legal theory suggests that this provision is usually invoked in situations where performance is not made impossible on permanent basis. So, for example, if there is no likelihood that performance could be resumed, then Article 374 can be invoked. But it doesn't mean that Kazakh courts would usually agree with this interpretation, but this is the way it should be interpreted properly, for example, the Russian interpretation. But again, because of this lack of clarity, it's very difficult to predict how a Kazakh court would act in a given event. For example, Article 404 also provides that for a possibility to unilaterally terminate contract when an obligation is impossible to perform. But again, if for example, force majeure lasts for 3 months, it's not clear whether a court would agree. So compared to that, AIFC law provides some balancing opportunity. It provides that if the impediment is temporary, the excuse has the effect. So the period should be reasonable, and after that, the contract can be terminated. So my understanding is that it would be arguably unreasonable to terminate the contract, for example, with reference to force majeure after 1 week, unless under specific circumstances of the case, one can prove that the performance within this specific week was extremely important. So although it will all depend on facts of the case, but it seems to me that to both parties to the contract, AIFC law will provide for some greater predictability, I would guess. And of course, parties are free to specify all of those provisions in contract, as well as in Kazakh law as well. Potential to reconsider. This is a very debatable question, and we have seen many questions from clients as to what could be done in relation to a contract in light of the ongoing situation with this COVID-19. And Kazakh law is not flexible. It simply does not allow a contract to be reconsidered with reference to change of circumstances or force majeure. For example, Russian law contains Article 451 in the Civil Code, which allows some room for the reconsideration of contracts. And also, when I yesterday reviewed Supreme Court's, Russia Supreme Court's overview, they also expressed position on this Article 451. So this is not possible under Kazakh law. But interesting thing about AIFC law is that Article 13 of the AIFC constitutional statute provides that in adjudicating disputes, the AIFC court will consider, among other things, final judgments of the courts of other common law jurisdictions. So this provision allows, in theory, to parties to invoke other doctrines available under common law to reconsider contracts. For example, the doctrine of US doctrine of impracticability, which refers to a situation not like force majeure, but considerable change of circumstances. For example, if due to COVID-19 certain products have become extremely expensive in the market, or they have become very difficult to obtain, Kazakh judicial practice would not support you. So under Kazakh law, you are supposed to perform the contract, and this is not going to be force majeure, no matter how expensive or how difficult it will be to perform the contract. While under US doctrine of impracticability, as I understand, you can argue that change of circumstances has occurred in there is excessively onerous performance, and then you can seek reconsideration of the contract. So this is all not clear at this stage, but at least we will see. We're yet to see how AIFC court will apply these doctrines, which countries' case law can be referred to. So at least an argument can be raised with reference to some other jurisdictions' case law that some remedies should be available in the event of force majeure, although AIFC contract regulations are silent on the possibility to invoke the notion of hardship, for example. Notice requirement. Kazakh law is silent on the obligation of a party to inform of the force majeure. Although this is usually specified in contracts, this is a usual business practice, and whenever a party does not make notice, it's usually Kazakh courts do not invoke force majeure. So one of the first things at which Kazakh courts look is whether there was sufficient notice, and whether that notice was timely and reasonable. It could be argued that the obligation to notify can be derived from Article 8. Article 8 contains a duty to act in good faith, fairly and reasonably, but I would personally, I don't personally believe that someone could be seen, or a Kazakh court would agree that a party is obligated to serve notice of force majeure. So based on Article 8, so it's a very debatable issue. As opposed to Kazakh Civil Code, AIFC law clearly provides that whenever a party is affected by force majeure, it needs to give notice of the circumstance, and it should notify of the effect of such circumstance on the party's ability to perform. And there's also a requirement to submit such notice within a reasonable time. And also there is an implication that if a party is not has not given notice, then it will be liable for damages. So this should be borne in mind. And of course, if you are not comfortable with this notice requirement, you can contractually opt out of this provision and specify some other notice requirement, or maybe different deadline or whatever. Evidence. In terms of evidence, Kazakh courts are not sufficiently competitive. Why? Because, as you know, Kazakh courts usually require document evidence. So, but before that, the general practice is that businessmen try to obtain a certificate of force majeure from the local chamber of commerce. Now it's called Foreign Trade Chamber of Kazakhstan. Our review of judicial practice suggests, and it's somewhat unusual, that although the certificate issued by the Chamber of Commerce is not binding, it simply expresses opinion of the Chamber of Commerce on a certain circumstance, whether or not it is considered a force majeure. And the court is not supposed to agree with this view. The general trend is that whenever a party provides such certificate, courts would agree with it. So if you have the option whether or not to submit to the Foreign Trade Chamber for the certificate of force majeure, you should try it. If you can obtain it, it will considerably boost your chances to invoke force majeure. If you do not obtain it, then it's still okay. You can still argue force majeure in court. But the problem occurs when parties specifically in contract specify that force majeure should be proven by the certificate, and the party fails to provide such certificate. Kazakh courts have taken a very inconsistent approach. Some of them mostly rejected force majeure provisions on the basis that the certificate was not obtained, although they could have established the force majeure themselves. Some of them disagreed. So again, Kazakh law provides less clarity on this specific criteria, but again, you can contractually write whatever you feel appropriate in terms of proving force majeure and what evidence is going to prove that force majeure. In terms of document evidence, for example, a force majeure occurred and a party needs to prove damages. If you cannot simply make a copy of software, accounting software, and submit it to Kazakh court. You need to convert it into some document evidence, either an expert submission or some documents, a certificate issued by the accountant. Emails are questionable. For example, if the party is saying that it hasn't submitted such email, some judges do not accept emails as evidence. So there are many issues with admissibility of evidence. For example, where as opposed to AIFC court. As I understand AIFC court rules, you can refer to whatever evidence available as long as it's admissible. And there is a great focus on witness evidence, while Kazakh courts extremely rarely allow witness evidence in economic disputes. So in terms of flexibility over evidence, AIFC court wins. Based on my analysis of AIFC law and experience based on Kazakh courts. Standard of proof. Standard of proof under Kazakh law is very high. There is provision in Article 68 of the Civil Procedure Code, which provides that certain circumstances of a case should be proven without a dispute. So it's not clear whether it's 100%, but it's way above 50%. So something should be established without dispute. The good thing is that this Article 68 is rarely invoked by Kazakh judges. They do not specifically refer to it. But the problem with it is that there is lack of clarity as to what is the approach to be taken by the judge. So if he wants, he can take the view that it's more than 50%. If he wants, he can say that it's not 100%. So this lack of clarity does not allow sufficient predictability in terms of outcome, in terms of sufficient evidence. So you can still submit sufficient evidence, which is like more than 50% proves a certain fact, but a Kazakh court can still reject it. So as opposed to that, AIFC court applies based on common law balance of probabilities. So basically you have to prove that a certain circumstance is more likely than not that it has occurred. So in that sense, I think it's going to be easier to litigate or arbitrate at AIFC. Overview of judicial practice. I'm not going to delve into very detail of the judicial practice. And my colleague Bakhyt will do this later during this series of webinars. But we've found some weird examples from judicial practice, which I thought might be relevant to discuss with you. There is general consensus that Kazakh courts considers force majeure circumstances which are beyond the control of one of the parties. So it should be some external event. However, for example, the Kazakh courts have consistently taken the view that if a party cannot perform the contract because of the fault of a subcontractor or maybe some third-party supplier, they would usually not consider it a force majeure. Or, for example, if a certain event which prevented performance of an obligation could have been avoided by the actions of such performing party, then they would also not be considered a force majeure. However, there are examples in judicial practice which are unusual. For example, we found a judgment where a Kazakh court considered a force majeure a road accident based on which a party could not supply some equipment, which is very unusual because the accident or the transportation was clearly within the control of one of the parties. Or, for example, a party was prevented from providing equipment because an injunction was placed by the state on such equipment. But the court did not go into consideration as to what was the reason for this injunction and whether the party's activities resulted in such an injunction. Similarly, for example, delayed issuance of permits by Kazakh state authorities was also considered a force majeure. Although a reasonable businessman, entrepreneur in Kazakhstan knows that you can never expect a state to issue permits on time. So a reasonable entrepreneur would have assumed that it falls within his or her risk. Similarly, a contractor was excused from performing a construction contract because groundwater was discovered or a fire occurred, for example. So these are somewhat weird, unusual exceptions from judicial practice, although they do not represent all of it. But it indicates Kazakh law does not, and the practices of Kazakh court do not provide sufficient clarity as to whether or not in your specific situation certain events would be considered a force majeure. So we are yet to see as to the practices of AIFC court and whether they will provide for greater predictability in that sense. Similarly, for example, we found some judgments where weather conditions, a flood or an extremely large volumes of rain were not considered a force majeure, which is also unusual. So, ladies and gentlemen, I've finished my presentation.